Hello, everyone. Welcome to a new episode of Immigration Fridays. I'm your host, Prashanthi Reddy, and we're here again to navigate the ever evolving maze of US immigration. What are we discussing this week? This week, we will discuss O1 visas. We all know that employers have been using H1B visas over the years to meet their hiring needs. But because the H1B visa has limited numbers, because there's a cap on the number of H1B visas that can be filed, often employers have problems and they're unable to meet or fulfill their yearly hiring requirements. So let's discuss how we can use an O1 visa in lieu of the H1 so that employers can meet their requirements. First, let's talk about the general eligibility to qualify for an O1 visa. Extraordinary ability in the field of science, education, business, or athletics is required to file for an O1 visa. This means a level of expertise indicating that you are one of the small percentage who have arisen to the very top of the field. Also, extraordinary ability in the field of arts, not just business and science, but arts as well. This means distinction. What does distinction mean? Distinction means a high level of achievement in the field of the arts. That's evidenced by a degree of skill and recognition substantially above that ordinarily encountered. So, not something that you and me have, but something that's special, that's above the ordinary. So, the artist should be so extraordinary to the extent that they are prominent, renowned, leading, or well known in the field of their art. So, famous people. If you're an artist and you're famous, then you're most likely to get an O1. Also, to qualify for an O1 in the motion picture industry or the television industry, again, you must demonstrate extraordinary achievement. Now, let's look into the evidence required to get an O1. To file an O1, you have to, of course, submit your I-129 petition. In addition to that, you have to get a consultation from, it's like an advisory opinion from a peer group. This could also include a labor organization or an expert, a person that has expertise in that particular field. There's some exception to this. You can waive this consultation requirement if you can show that there are no experts in that field or there are no labor organizations in that field. You can also waive the consultation requirement if you have previously received a consultation and you've come previously on an O within the last 2 years and you're coming again for the same purpose. So then you can waive the consultation requirement. So basically, consultation from an advisory opinion, consultation or advisory opinion from a peer group, from a professional organization, a labor organization, for example, if you're coming as an actor, then from Actors Guild, right? Just to give you an example. You also have to submit a contract between the petitioner and the beneficiary. This contract will outline the terms and conditions under which employment will be undertaken. An itinerary has to be prepared. The itinerary has to show and explain the nature of the events or activities, the beginning date and end date of these activities, and a copy of the itinerary for these events or itinerary activities has to be submitted, as I was saying. The petitioner must establish that there are enough events or activities to cover the duration of the O1 that you're asking for. Another requirement, of course, you have to submit evidence demonstrating O1 eligibility. So this, to show that you're extraordinary, there are many different types of evidence that you can submit. Some of them are, as I was talking about, being famous in the field if you're in the arts. So you can submit newspaper cuttings, you can submit social media, printouts. If you're in the sciences, you can submit publications, memberships. If you've judged the work of others, these are only a few examples of how you can demonstrate that you have extraordinary ability. Now let's talk about the advantages of O1 over a H1. Firstly, most importantly, there's no cap for an O1. So there's no lottery system. There's no maximum number of applications that can be filed Any number of applications can be filed, so that's a big advantage for employers. There's no filing deadlines. You don't have to file by a certain date every year. For a H1, you have to file the registration by a certain date. Once you're picked in the lottery, you have to file your H1 within a certain date. Otherwise, you forfeit the H1. You forfeit being able to file your H1. No such filing dates for the O1. You can start immediately on an O1. So you don't have to wait for October 1st to start, the beginning of the fiscal year. You can start anytime because there is no cap on O1 visas. You can keep extending your O1 visa. There is no limit. For H1, there is a limit of 6 years. For O1, as long as you show that your employer requires you, as long as you can show that the employer has worked for you, you can continuously extend your O every 3 years. Most importantly, the O1 acts as a stepping stone for EB1, which is the Employment-Based Category 1 green card preference. EB1 is the best kind of green card that you can apply for because the wait times are the least for EB1 when compared to EB2 and EB3. And the requirements for O1 and EB1 are almost the same. So if you qualify for an O1, you're likely to qualify for an EB1. So you see there's a lot of advantages of the O1. But however, obviously approval of an O1 doesn't guarantee you that your EB1 will be approved as well. And that's a wrap for Immigration Fridays this week. Immigration laws and processes can be very complex. If you need any kind of help, please contact me, prashanti@readyesq.com, or call us 212-354-1010. Keep watching. See you next week. Thank you.